Section 1, Article 3 of the 1987 Philippine Constitution provides no person should be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. So Group 10 are assigned to discuss to you the due process of law, which constitute what is the meaning of due process, what is the definition of person, deprivation, life, liberty, and property, what is substantive due process, what is procedural due process, what are judicial due process, and lastly, administrative due process.
Section 1, Article 3 of the 1987 Constitution provides, no person shall be deprived of life, liberty, or property without due process of law, nor any person be denied the equal protection of laws. Due process and equal protection cover all persons, whether citizens or aliens, natural or juridical, or artificial. Likewise, it protects the right to life, liberty, and property. The Bill of Rights refers to the declaration and enumeration of the fundamental civil and political rights of a primary aim protecting the person from violations by the government. Person is defined as the Due Process Clause protects all persons, natural as well as artificial. Natural persons include both the citizen and aliens. We will talk now of deprivation. To deprive is to take away forcibly, to prevent from processing, enjoying something. As applied to the process, deprivation connotes a denial of the right of life, liberty, or property. Deprivation per se is not necessarily unconstitutional. What is prohibited is deprivation of life, liberty, or property without due process of law. Now, let us talk about the meaning of life, liberty, and property. While the rights are intimately related, they have a hierarchy. As to their order, the importance, the right to life comes first, followed by the right to liberty, and then the right of property. Now, what is life? What is life is the right to life. The right to life refers not just the physical safety, but also to the importance of quality of life. Thus, the right to life means not just the right to be alive or the right to be one's limbs against physical harm, but it also includes the right to a good quality of life. Liberty, on the other hand, what is it? It includes negative and positive freedom. Negative freedom means freedom from or absence of physical constraints, while positive freedom means the freedom to exercise one's faculties or the right to enjoy God-given faculties in unlawful ways and means. This includes the right to live, to work where one pleases, to earn his livelihood by any lawful calling, to pursue vocation, and to enter into contracts. On the other hand, property, as the number 3, is the right to property that refers either to the thing itself or a right over the thing. As a thing, the property is anything capable of appropriation, and it could be a personal or real. As a right, it refers to the right to own, use, possess, alienate, or destroy a thing. The Constitution uses the property in the sense of right, and as such, it includes, among others, the right to work, one's employment, profession, trade, and other vested rights.
There are two aspects of due process. Due process evades a precise definition. The purpose of the guarantee is to prevent arbitrary governmental encroachment and against the life, liberty, and property of individuals. The guarantee of the due process serves as a protection against arbitrary regulation or seizure. Even corporations and partnerships are protected by the guarantee insofar as their property is concerned. It is a constitutional guarantee against hasty and unsupported deprivation of person's life, liberty, or property by the government. While it is true that the state can deprive its citizens of their life, liberty, or property, it must do so in observance of due process law. This right is the embodiment of the supporting idea of fair play, and its essence is that it is a law that hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. Due process can be invoked when the act of the government is arbitrary, oppressive, whimsical, or unreasonable. It is often directed against the acts of the executive and legislative departments. There are two aspects of due process. One, substantive due process. The substantive due process requires that the law itself is valid, fair, reasonable, and just. For the law to be fair and reasonable, it must have a valid objective and is pursued in a lawful manner. The objective or purpose of the law is valid when it pertains to the interest of the general public, as distinguished from those of a particular class, and the manner of pursuing such purpose or objective is lawful if the means employed are reasonably necessary and not unduly oppressive. Procedural due process, on the other hand, essentially requires an opportunity to be heard in which every person is given the chance to defend himself or explain his side through protection of general rules of procedure. It contemplated notice an opportunity to be heard before judgment is rendered.
In judicial due process, as held in a long line of decisions, the following are the requirements of procedural due process. In every judicial proceedings, number 1, there must be an impartial or objective court or tribunal court with judicial power to hear and determine the matter before it. Second, jurisdiction must be lawfully acquired over the person of the defendant and over the property which is the subject of the proceeding. Third, the defendant give the opportunity to be heard through notice and hearing. And fourth, judgment rendered after a lawful hearing. In impartial and competent court, it is clear that a court affected by bias or prejudice cannot be expected to render a fair and impartial decision. As our Supreme Court has declared, every litigant is entitled to the cold neutrality of an impartial judge. By competent court is meant one is vested with jurisdiction over a case as conferred upon it by law. For example, a regional trial court is competent to try a prosecution for murder but not for violation of the municipal ordinance. Number 2, the jurisdiction. In action in person, such as a complaint for recovery of a loan, jurisdiction over the defendant is acquired by the court by his voluntary appearance or through the service of summons upon him. This may be affected personally or by substituted service, or in exceptional cases, by publication. In actions in rem or quasi in rem, such as land registration proceedings of the foreclosure of a real estate mortgage, the jurisdiction of the court is derived from the power it may exercise over the property. Jurisdiction over the person is not essential, provided the relief granted by the court is limited to such as can be enforced against the property itself. Hearing. Notice to a party is essential to enable it to adduce its own evidence and to meet and refute the evidence submitted by the other party. Every litigant is entitled to his day in court. He has a right to be notified of every stage thereof so that he may be heard by himself and counseled for the protection of his interest. And now, let us go to appeal. The right to appeal is not essential to the right to a hearing, except when guaranteed by the Constitution. An appeal may be allowed or denied by the legislature at its discretion. If allowed by statute, it must be exercised strictly in accordance with the provision of the law and rules. Let us now go to the exceptions. Nevertheless, there are cases in which the essential requisites of notice and hearing may be omitted without violation of due process. Among these is the cancellation of the passport of a person sought for the commission of the crime, the preventive suspension of civil servant facing administrative charges, the restraint of properties for tax delinquency, the padlocking of restaurants found to be unsanitary, or of theaters showing obscene movies, the issuance of temporary protection orders, and writs of preliminary attachment or writs of possession, and the abatement of nuisance per se. Next is the nuisances. A nuisance per se is objectionable under any and all circumstances because it presents an immediate danger to the welfare of the community. This kind of nuisance may be abated summarily, that is, without necessity of judicial authorization. A nuisance per se accident is objectionable only under some, but not all circumstances. There are being situations when it is perfectly legitimate and acceptable. It has been described as the right thing in the wrong place, like a patties factory in a residential area. Next is the presumptions. Presumptions would be a statutory presumption deny the right to a hearing insofar as the person affected is precluded from introducing evidence to rebut the presumption. The accepted view is that it would not, provided there is a rational or natural connection between the fact proved and the fact ultimately presumed from such fact. And next is judgment. The right to a hearing could be meaningless if in the end the judge could disregard the evidence and adduce the parties and decide the case on the basis of his own unsupported conclusions. To ensure against such arbitrariness, due process requires that the judgment be based upon the local hearing previously conducted.
Let's talk about administrative due process. In administrative proceedings, the requirements of procedural due process, known as the 7 cardinal primary rights, are 1. The right to hearing, where a party may present evidence in support of his case. 2. The tribunal must consider the evidence presented. 3. The decision of the tribunal must be supported by evidence. 4. The evidence must be substantial. Substantial evidence is such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. 5. The evidence must have been presented at the hearing or at least contained in the record and known to the parties affected. 6. The tribunal or body of any of its judges must rely on its own independent consideration of the evidence and not merely rely on the recommendation of a subordinate. And 7. The decision must state the facts and the law in such a way that the parties are apprised of the issues involved and the reason for the decision. In the interesting case of Zambales Bromide versus the Court of Appeals, a decision rendered by the Director of Mines was appealed to the Secretary of Agriculture and Natural Resources. The Director of Mines was later promoted to the Secretary of Agriculture and Natural Resources, and in this capacity, reviewed and not surprisingly affirmed his own decision. The Supreme Court annulled the proceeding, calling them a mockery of justice. In administrative proceeding, including those before the Ombudsman, cases may be submitted for resolution on the basis of affidavits and pleadings. As long as a party is given the opportunity to defend or her interest in due course, said party is not denied due process. As previously noted, it has been ruled that any defect in the observance of due process requirement is cured by the filing of motion for reconsideration. In Naseco Guards Association versus National Service Corporation, the Supreme Court held that a re-evaluation, contrary to what the respondent claimed, is a process by which a person or office, in this case the Department of Labor and Employment Secretary, revisits its own initial pronouncement and makes another assessment of its findings. In simple terms, to re-evaluate is to take another look at a previous matter in issue. A re-evaluation does not necessitate the introduction of new materials for review, nor that it requires a full hearing for new arguments. From a procedural standpoint, a re-evaluation is a continuation of the original case and not a new proceeding. Hence, the evidence, financial reports, and other documents submitted by the parties in the course of the original proceeding are to be visited and reviewed again. In this slide, the respondent has been given the opportunity to be heard by the Department of Labor and Employment Secretary. Finally, it should be mentioned that a preliminary investigation is a component part of due process in criminal justice. The denial of one's right to a preliminary investigation in the absence of a waiver is therefore a denial of due process, even if the right to a preliminary investigation is just a statutory right. So to recap, hopefully we were able to discuss thoroughly the following topics. To start with the due process of law, the meaning of the due process, person as herein defined, deprivation, life, liberty, property, substantive due process, procedural due process, judicial due process, and lastly, administrative due process. We are hoping that you learned something from this video. Thank you and good day.